The idea that the guys that you see as just a level of talent, you're going to have better talent enter the space. Instead of like Dave Smith, who's like a second, third tier comedian, you'll have Louis C.K. You'll have Sebastian Maniscalco. You'll have Stephen A. Smith. You'll have Kevin Hart. You'll have A-level talent that wants to enter the space and start owning these constituencies. You know, Benny Johnson, Ben Shapiro. This is not A-level talent.
Things are going to start happening to me now.
I think Tyler is amazing.
And I'm a fan of this show. I've watched several episodes.
Thank you, Tyler. Thank you, Tyler. You stink, Tyler.
Never promise crazy a baby.
Oh, I like that. That's a cool idea.
Are either of you homosexuals?
I go both ways. What do you think?
You mean like flaming or?
No, we're not homosexual, but we are willing to learn.
But I do wonder for others in other cases whether libertarianism today is just an excuse for many on the right to act selfishly.
Look at me. And then some fat asses in Washington started having opinions. The Olympic Committee started having opinions. You bitch, I know you. You started writing your opinions.
And it just makes me wonder, you're dead, bitch. You know, why are you doing this to this poor guy?
I don't care. I'm a libertarian.
There we go. This is amazing. I thought I had everything ready to go. And then my wife and I, we went out. We went to a happy hour. We had some pizza. We had some beer. She had some wine. Come home, plenty of time-ish. And then I start the show. And I'm like, okay, I'm getting my stuff going here. Mute myself so I'm not taking into. And then it's disaster, scuffing the stream. Yes, thanks everybody. Welcome aboard. Let's just get right to the full chat. So what do we got going on here? Thank you, Dwayne in here, Jordan's in here, Rootless Redneck, muted. Barnes did this, quite possibly. And I've got. Let me just throw this up here. Barnes is right. Is he? Is Barnes right? Are we going to go through this here today? Barnes being right? Yes. Mea culpa to Barnes. And I was actually pulling up because we're going to talk. Here's what's on tap. We're going to walk through real quick Nick's appeal and the ruling on that. And that's where Barnes got it right. We are going to pay mea culpa. So sorry. I apologize to Barnes. He was completely right. We will get to that. We're also going to play a little thing here where he is, this is the title, Lawyer Representing Covington Catholic Families Considered Legal Action. He never represented them. Barnes, and it's a picture of Barnes. Let's see, go here. Oh, geez, I'm not ready. I'm not ready to go. Let's go into the studio mode and I'll fix it here while we talk about some of this stuff. Okay, so YouTube properties, there we go. There we go. So let's transition over there. There you go. Barnes, we're gonna play that. So that's one other aspect we're gonna get to. So the appeal, we'll walk through that. We'll play Barnes, how he's right. An update: new legal defense for murder and crimes. The charges themselves are the problem. Okay, we're gonna walk through that. Just a tad bit of an update. Family law. Trans dad who lost his son. He's black-pilled on family law. He's men's rights doom. This is his name, Jeff Younger. We're going to talk a little bit about that. Is everything that he's presenting to the T? Now, this guy got screwed over. I will say that. But who's to fault? Is the story as you know it, exactly as you know it? That's the question. We will walk through that. And I've got I got a little bit of details in there. Okay, so let me see if I could find here. This is Tyler. You should have been ready. Look, I was reading, and then we'll do the mailbag. I was reading here someone. Maybe we should just do this one real quick, which is comments from the last show. The teachers the sexy teachers that are fucking kids and getting caught. Maybe we'll walk through that because some people don't like how I hem and haw. I don't get to the point. People, this is getting to know each other, right? Do we have any music for this? Let's see if we do. I played adult education, which is maybe it's this. All right, let's get to know it. Let's get to know each other. A little Marvin Gaye here. Okay. Okay, and here is the appeal answer. All right, let's go over to the slide. Maybe I'll have to do this here. So I hope everyone's doing good. All right, Marvin's a little too gay. Little too gay. Slideshow, I think we can do this here. Featured. Okay, maybe we'll try this here. No, that's not gonna work at all. Okay, so I want to get rid of the thumbnail, and we'll have to fix this. This is what happens, folks. I'm sorry. So we'll get to it. Where things will happen here. I don't know why this is doing this up front here. But this is the Nick appeal. We'll get to it here completely. I think I'm gonna have to remove this and come back to it. Nope. Okay, this is all screwy. Screwy, folks. It tells you it's screwy. All right, let me try one other aspect. We can get to it here. I hope everybody's been good. Open with. Let's try a different system. Okay, I think this will work best. There we go. Well, that's not what I wanted. How about right over here? There we go. All right, now we are booking. Okay, so hide sidebar. There we go. That's enough of that music. Okay, it's the recursive Rekieta, and I'm sorry, folks. This is just the way it's going to be. Like, what's interesting is last show we did, I talked about the sexy teachers and got good feedback. I mean, good views here, but people do get all worked up about certain things, and I don't always understand. Okay, so last we heard there was a Frank's motion for Nick Rekieta, and he filed an appeal, an interlocutory appeal, which is in the midst of the trial or in the midst of the action. He says for whatever reason he needs to file this appeal, and it was due to the Franks. And he's like, look, based on the fact that this has a detrimental effect to the outcome, this needs to be appealed now. And so he does so. And this is the answer to the ruling on the appeal. It's a simple 4 pages, like 3 and a little over 3. We'll read it here. State of Minnesota respondent versus Nicholas Robert Rekieta, petitioner, special term order. Here we go. Make sure we can see all this, everybody. Okay. Considered and decided by Segal. And by the way, part of this appeal, Robert Barnes is right. And we are going to talk about that. Okay. And I'm going to have to say, hey, I was wrong. I was wrong on the Robert Barnes, and he was right. And so we're going to talk about that. But first I'm going to go through the appeal, and then we're going to, when I get to the magic lines, we will play Robert Barnes' comments and see how he's right. And this is me, Tyler Yonke, giving out the big to Robert Barnes for being correct. Okay, I mean, it doesn't always happen. Petitioner Nicholas Robert Rekieta is charged with second-degree controlled substance crime, unlawful possession of a firearm, and child endangerment based on the evidence seized. Remember, child endangerment was added later. Child endangerment is still at issue, and we still have ongoing. He claimed Nicholas Robert Rekieta claimed his kids are back and the CPS issue is over. Could be, we don't know. Evidence seized after the search warrant was executed at his residence. He moved to suppress the evidence and dismiss the charges, and he requested an evidentiary hearing under Franks v. Delaware 438 U.S. 154 171 1978 case to investigate whether the search warrant application contained material misrepresentations regarding a social media video, among other things. and it's so hilarious now that he is coming after people for kind of, and they can use the same defense of he's like, I'm going to DMCA you. And they're like, I don't know. There's a different watermark on here, right? A different watermark means it's completely altered, Nicholas Rekieta. Regarding social media video, among other things, the district court denied petitioner's motion for a Franks hearing, and next page, his motion to suppress evidence and dismiss charges. Petitioner seeks discretionary review of the district court's order denying his I don't know why I'm having trouble reading his motion. It's been a long week. It's been a really long week. I'm moving offices finally coming up here just across the hall. And so you'll see that whole new situation. His motion for a Franks evidentiary hearing. Petitioner argues that this court should grant discretionary review in the interest of justice because the Franks issue is important and doubtful, and resolution of the issue would obviate the need for further proceedings. The state has not filed a response. That is the ultimate thing, and that's where I'm going to get here. Let's go to Barnes and see if we can play specifically what he says about filing responses, okay?
He said, oh yeah, I was watching the original video. No, he didn't even download it. What he did is he saw somebody else talking about it on another video. And this was they discovered this going through the process. So he hid the fact that he watched somebody else's video of something. There's video of me out there with that people made AI memes of me saying all kinds of crazy.
Oh, by the way, I just backed this up a little bit just to show the preposterousness of Robert Barnes, which is he's now comparing someone downloading the entire video. And remember, this is what Nick has problems with the Alyssa clips, which is in their entirety, without changing it, without altering the content at all. She is reposting his stuff. And he's like, hey, I'm going to DMCA this, copyright infraction because you are not altering the content. Now, Robert Barnes is saying, okay, someone who did that, who cogs the life or whatever it was, Robert Barnes is making the claim that that is equivalent to someone using AI to parody him. Okay, anyway, this is the level you have here of deceit by him and the long-haired weirdo.
They have me as Breaking Bad. They have me as, there's over 100 versions of it. Imagine some cop getting a warrant for my house because he watched that. And this guy, he lied about that. So what you request? And
once again, I'm sorry to break this down, but this idiot, I know he was just in the hospital. R.I.P. No, he's not dead. Godspeed, or whatever you say, to heal up quickly. Yes, we need you back so that we can mock you more mercilessly. You are so distorting. If you were in court right now, I'd be objecting, facts not even evidence. This have nothing to do with this case. Go on, when your little straitjacket.
Is what's called a Franks hearing.
When I say straitjacket, I'm mocking him for wearing a vest because he's fat. Fat men wear, and no offense to fat people, I'm just saying he is particularly trying to, that's why he wears a vest. That's the only reason why.
And the prosecution, if they're worried or nervous that they might lose a Franks hearing.
Here we go.
Is they go in and they request, we need to have special briefing, judge, give us extra time, If they're confident, 90% of the time, they go into the court and say, here's where they're wrong, boom, 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 let's move on.
Okay, that's where they're wrong. So he's actually...
Instead, they go in front of the judge and we need extra briefing. Also, we need to figure out how we can try to pretend the cop didn't lie or try to get him to tell another lie, or I'm the prosecutor thinking about how do I get out of this case. If a smart prosecutor uses this as an opportunity to get a plea deal on the table, to get a deal done.
Okay. What Robert Barnes is saying there, and we've talked about this before, which is if in his little mind here, and it's a big skull, but it's a little mind. And by the way, I think Robert Barnes is very intelligent, but he is deceitful, okay? But what he's saying here is dishonest, which is the DA would not file a response if they were confident. Okay, they wouldn't do it. All right, let's go back here now to, let's go back here to, that's not the one. Where is, okay, hang on a moment. I'm gonna have to find this one here. There we go. Okay. Back to the appeal. The petitioner seeks discretionary review. The district court, blah, blah, blah. The state has not filed a response. I am sorry, Robert Barnes, you are correct. If they were so confident, they wouldn't even file a response Finally, it comes to fruition. There is the cheering fans, everybody for Robert Barnes. He is correct. The state did not file a response. Why didn't they file a response? Because this appeal was dead in the water. Robert Barnes finally tells us something we can hang our hat on, which is the state didn't file a response. This is the only thing that I'm talking about with this appeal. Okay, we're going to read through it, but this is how ridiculous this guy is, that finally we got something. And I'm saying, I'm sorry, Robert, you are right. Finally, you are right. You're right about something, which is that when the case is so in your favor, you're not even going to dignify a response. That's exactly what we have here in this case, which is the state did not file a response. Criminal defendants generally do not have a right to appeal until final judgment has been entered. State, and we're not going to read all the citings, but this court may, quote, allow an appeal from an order not otherwise appealable in the interest of justice. Minnesota Rules of Civil Appellate Procedure 105 govern the procedure for the appeal. In determining whether to grant discretionary review, this court considers multiple factors, including whether the ruling is questionable or involves an unsettled area of law, the importance of the legal issue presented, and whether the legal issue would evade review if the appeal is deferred until the underlying case has been decided. And then it gives a case, Gordon v. Microsoft. General discretionary review is only intended into important legal questions that have broad applicability. The petitioner must also show a compelling reason for this court to grant discretionary review. So it sounds like to me the court is really taking this on like, is this even an appealable type of process, an issue? Did you go through that process? Is this the proper venue for even doing this? Should we even, think about it this way. A lot of cases are in this, which is standing. You may have a valid case, could be, but do you even have standing to bring this case? Are you even one of the parties to this case? Is there jurisdiction over you? What are all the reasons for standing? This is kind of the same issue you can understand for this appeal. Petitioner does not explain why the district court's pretrial ruling denying his motions to suppress evidence for Frank's evidentiary hearing requires this court's immediate review. And it's see Minnesota R Civ App P105.02C, requiring a statement why an immediate appeal is necessary and desirable. So he didn't even do that. He didn't follow the actual procedures in appeal for this thing, or his attorneys. Moreover, this court generally does not grant petitions for discretionary review of pretrial rulings because the defendant may utilize the procedure in Minnesota R Crim P 260.01 subdivision 4, which permits expedited review of a pretrial ruling that is dispositive or would make a contested trial unnecessary, State v. Smith. Stating defendant seeking discretionary review must show why he should not be required to proceed by stipulating to the facts and waiving a jury trial to obtain review of pretrial ruling, although review would be somewhat delayed. By requiring petitioner to appeal from any final judgment, the pretrial ruling will not evade review, and a defendant's interest in avoiding the time and expense of a trial does not by itself establish a compelling reason to extend pretrial discretionary review. The petitioner does not otherwise show a compelling reason for this court to extend its discretionary appellate jurisdiction when the pretrial issues are fully reviewable by an appeal from any final judgment. In other words, wait until the whole case runs its course, file an appeal. This issue is fine for that. We don't want an appeal at this point. It is so hereby ordered. The petition for discretionary review is denied. So they didn't even take it on its merits. The appeals court took this appeal based on the fact, was this even properly before the court? Now, to relate it to something I deal with all the time, ex parte motions, these are emergency hearings, and you've got to show, you file a motion, you get a court date, half a month, it's usually a month and a half or somewhere in that range, 30, 45 days out, you get a hearing, but sometimes you need a ruling before that. So you file an ex parte, it's an emergency, and the first number one thing the court looks at is one of the parties going to be irreparably harmed if we don't make this, request, if we don't take this under advisement? And that's the thing they have to do. That's kind of what you're looking at here, which is even to get to it, is there even standing to do this? You walk through your issues before the court. And the respondent, the state, didn't even file a response because they felt so sure about this. Okay, that's how bad it was for Nicholas R. Rekieta. Denied. Robert Rekieta got the L. His dog is not. His name is not Cog. It's Jobless Johnny. Okay, I'm sorry, William. God, so true. Is this live? Yes, Minder, it is. Not Memorex. Lawyer being deceitful. Heavens to Murgatroyd. Murgatroyd, showing your age. I don't even know what Murgatroyd is, and I'm probably older than all of you. It's hard to believe it happens, but it is becoming more common. Rootless redneck. Yes. Okay. Thanks, guys, for joining us in there. This camera is a little shaky. What's going on here? You know what? Let me do this. I do want to be able to use these. Let's see here. I think I know exactly what. Yep. Not connected to the internet. There we go. It's just it's a shit show from point one to, oh, look at that. That's bad. Let's see if we can fix this here. I'm showing the camera. I don't know what's going on. Let's you guys get to walk through this with me. So, oh, there we go. Okay. Wow, this is a rough night for us all. Rough night. I don't even know. Let's play adult education one more time. I'm a big fan of Hall & Oates. People, you know, there's certain groups when you think of them at the time, they got the shit. And this isn't necessarily my favorite song by Hall & Oates, but I think they're a great band, a lot of talent. This is water. This is Kirkland Sparkling Water. Just throwing that out there. All right, so Nick gets denied. Nick gets denied extraordinarily. So just another L for the Nick. And what I think we're going to do, let's play this. I have not listened to this yet. I found this the other night, and I was like, holy shit, what is this? So let's just play. This is Robert Barnes. Now, remember, Robert Barnes was there was a lawsuit threatened against him for pretending to be the attorney for the Covington kids. Okay, so he was not their attorney. I'm gonna fix this here. He was not their attorney, but he was claiming to be, and their attorneys and Nick Sandman had to come out and basically say, stop doing this or we're going to file a lawsuit. So I'm curious to watch to see what this dope is saying here. Because remember, this is before they were going to actually sue. He's not their attorney, okay? And they were going to sue him later to make him stop pretending to be their attorney. So let's play this, just in anticipation of what is he saying here.
Robert Barnes. He's representing the families of at least 3 of the Covington Catholic High School students. Robert, welcome to our broadcast.
He didn't.
Glad to be here.
Since this video has gone viral, Nick Sandman has received death threats. There have been calls for him and other Covington Catholic High School students to be doxxed or to have their personal information posted online. What legal recourse are you pursuing to make this stop and hold people accountable?
Well, what the families have agreed to is that if anyone who has issued a false statement, anybody in the media, anybody in the celebrity community, anybody with a substantial social media platform will retract, correct, and apologize within the next 48 hours, then they will not be sued. But anybody who refuses to do so will be subject to suit, and those suits will start to be filed next week for defamation, for libel, for invasion of privacy. Today, my law offices received a bomb threat just because of my representation of the kids in Covington. It will not deter us in any way, shape, or form.
Okay, let's. Does anybody believe they received a bomb threat? I mean, what probably happened is someone's like, "Hey, buddy, maybe Robert Barnes had indigestion, okay, and so it was so bad that he's like, I need antacids, or I'm gonna like blow, and they're like, it's a bomb threat. I don't know. I'm really stretching the comedy efforts here, but let's be honest, he's not received a bomb threat. That I don't believe.
Form. This is what has been unleashed by the establishment press, allowing the lies and libels to be
So the establishment press issued a bomb
told
threat
about these innocent kids.
Have you given notice to media outlets and individual reporters, or is this it? Is this your calling card?
Well, I did it publicly today on nationalized television, but I've also been doing it directly to individual reporters, individual celebrities, individual commentators, affording them the opportunity. And to their credit, some have. Congresswoman Omar retracted her statements today, deleted her tweets that had false information in them. Others, Jake Tapper before, has also done so. Kara Swisher did it before then. So I'm hopeful that more people will do it. About half of the people that we've requested to do it have done it, but there are some people out there that refuse to. And if they continue to refuse to and act malevolently towards these innocent kids who are giving them the opportunity of grace, an opportunity of redemption through confession, of retraction of their false statements, if they continue to go on anyway, then the only remedy is deterrence through punishment of a lawsuit.
Kenton County, Kentucky prosecutor Rob Sanders has launched investigations into threats of violence against the high school. You're pursuing this from the libel perspective. Twitter suspended the account that helped amplify and spread the video, but legally, do social media platforms, in this case Twitter, bear any responsibility for content that's proven to be false?
In the context that Twitter has terms of service that they have employed and used against conservatives repeatedly that they're not following through here. So there's people who are public celebrities who have big social media platforms on Twitter who have actually called for individuals to be punched in the face. And yet these individuals' accounts aren't being suspended at all. And yet other conservatives whose interpretations of such statements were often misrepresented or misinterpreted by Twitter were actually permanently banned from Twitter. So by Twitter's terms of service, they're not being consistent in the application of those rules. When here you have adult professionals threatening the well-being and safety and threatening physical.
Sorry, does he want them to be suspended? Does he want everyone to be suspended, or just the right
violence
people?
Against minors?
What do you have to say to people who say that Nick Sandman should apologize?
He has nothing whatsoever to apologize for.
Agreed.
Especially, you consider this as a kid who's who's facing lefty protest culture for probably the first time, who hasn't dealt with their confrontational tactics, their abusive techniques. They're almost like the stockerazzi of LA in the way they harass and harangue and try to provoke a response. And he didn't respond like Alec Baldwin. He didn't go out punching anybody. Instead, he tried to stay still. He said nothing demeaning in response. He tried to be respectful and not turn his back on the individual. He tried to address him directly. He deterred other people from acting in any negative or adverse way. So really, he acted like an extraordinary individual, especially for someone so young who's experiencing something likely for the first time.
Attorney Robert Barnes of Barnes Law, representing several of the Covington Catholic high school families. Thank you for joining us.
Okay, let's see. Oh, comments turned off. I can't even make a comment about how Robert Barnes is a big fat whatever. So there's let's see here. Robert, I've had the video or the article before. Robert Barnes, Covington kids attorney. Let's see what this brings up. I'd say suit. I've had it before. Robert, man, I mean, maybe he was representing some of the other ones. But okay, I've found it before. There's a whole article. Okay, I'm not finding it right now, but I've found it before, so we'll just let it go. I mean, look, it's Robert Barnes loves to put himself in the place here. It's typical of Mr. Barnes. Do we really say this is we are feeling sorry for him? I don't know. But what I want to talk about next, we'll do this real quick here. See, my screen is always fucked up here. Let's go back in here. Okay, so this is what you're starting to see now. The ICC, which I'm not a big fan of. It's this international whatever. It's like the United Nations type of thing. But here's what you're starting to see. They issued arrest warrants for Netanyahu. So here's what Senator Mike Johnson said. The ICC's decision to target America's ally Israel is anti-Semitic, reprehensible, and completely ridiculous. It has absolutely no jurisdiction over Israel or the United States. And these illegitimate warrants are an attack on the very concept of sovereignty and due process. The United States should vote immediately on the bipartisan illegitimate Court Counteraction Act. And President Biden should take clear steps to prevent these warrants from being enforced. If Senator Schumer and Biden do not act, they will most assuredly invite future lawfare against Israel and the United States. We cannot afford to show weakness. Now, some of this I don't have a problem with, right? Some of this is exactly right. This governing, this global global body that Alex Jones pushes back against all the time. Completely, I understand. But here's the problem. they're claiming nothing in this report says because Netanyahu is a Jew, right, that he therefore should be subjected to murder. They're like saying, look, we have arrest warrants because of what Israel is doing to Gaza and the Palestinians there. That's only what it is. What's interesting is this is now a new concept for defending yourself in court, right? I'm a black man. These charges are racist. These charges themselves are racist. That's what Speaker Mike Johnson is saying. And it is so hilarious coming from the right that now these concepts of simply by being a black man or simply by being a Jew, the charges themselves are illegitimate. That's what he says. That's now some sort of defense. Now, luckily, yet, this is not an actual legal defense, right? I mean, it's the most ridiculous thing. And by the way, it's fanatical the way that some of the right and many of the people in politics just fawn over Israel. It's to the point. I mean, if you and I've done this over and over, and we've done this back in the day with BLM, which is everything that comes to pass. You just replace the word white with black or the DEI or 1619 Project type of thing, which is you replace it in reverse racism, right? The reality, which is if you acted this way and and you just swapped white and black, it would be like disgusting, right? In the eyes of the government, of everybody. They'd be like, oh, that's ridiculous. That's completely racist. Yeah, but it can go both ways. But if you replaced Israel with Russia right now, if every government official went over to the Kremlin and put their hands on the wall of the Kremlin and got money as part of their, wouldn't we have a problem with that? We would have a big problem with that. And Tyler, you're being anti-Semitic. No, I'm not. What I'm being in is legitimately I'm not being hypocritical. That's the whole point, which is America first. If that's your plan, that's fine. If you say no, I adhere to a foreign government. And that is the evil thing, because we've seen the IHRA's definition of working, which means it's malleable, of anti-Semitism. They will say you're anti-Semitic for even equating that. Now it's to the point of you're anti-Semitic if you don't believe that what Netanyahu is doing is legitimate, right? And you can have arguments over that. But I mean, I think anybody with a rational mind is going to see what's happening in the bombing and be a little bit like, okay. And by the way, I would just point this out right away, which is it's not two countries going at it. These are an occupied party, right? It's literally like they're citizens that they're going at. So it's just a little bit different, but we can have those arguments. But if you're going to immediately say that there's anti-Semitic, it's racist to arrest, Mike Tyson just had this fight, right? And back in the day when he was supposedly raping his girlfriend, or Robin Givens, he was beating the shit out of her, his wife at the time. If you just say, oh, that's racist, he should be able to do that. And you'd be like, well, that doesn't make sense. Is that a defense? Is that now a defense where you just call the charges themselves racist, and therefore you get to forget about them? Maybe so. So anyway, that's an interesting legal thing. Barnes has a custom Baldo helmet. This is Margot. Lily Lynn, anyone that listens to Barnes or Rekieta will instantly lose brain cells from their arrogance and stupidity. Yeah, and give them $30 billion more dollars. But then say it's legitimate when used against Putin. Right. Nick's warrant was crap. Trump won. Nick's warrant was crap. Talk to me about that. I'm waiting for that. We've gone over that one. It wasn't crap. If you think that was crap, if you think the warrant was crap, I've got an attorney for you. Hire this guy, this Yahoo over right here. Next time you need an attorney, and it wasn't crap. I'm sorry, we've been through that. It wasn't crap. He had coke in the home. The kids had got coke. We just talked about this last week, where Nick is talking about, once again, pushing back at the CPS. It's all a collusion. And I'm like, okay, but wait, you used the letter that CPS wrote as a way to try to exonerate yourself, right? They wrote this letter, and then The investigation continues. They find coke in the house. They find coke all over the place. You're high as fuck. Your kids have coke. You didn't get them retested. I don't know. If you guys want to still nose guard, that's perfectly fine. Okay, let's talk about this. So this is a guy, Jeff Younger is his name, and I feel a lot of sympathy with him. There's a tweet he had here. I lost all parental rights to my sons. Goodbye, boys. Perhaps we will meet when you are adults. California Judge Juhas gave my ex-wife authority to castrate my son, James. All contact with my boys must be supervised. I won't do that. I send letters and gifts to the sons. My ex is not required to give them to the boys. I cannot post pictures of my sons. Let my story be a cautionary one for young men. Fathers have no rights to their children. Do not enter family law system. Okay, well, let's finish his writing, and then we'll talk about each little subject here. A number of well-meaning people and some ill-meaning people too have urged me to attend supervised visits. That is a bad idea. It's bad for the kids. Supervised visitation reinforces in a child's mind that the father is dangerous, that something is wrong with him. It's also bad. Let's see where else he goes. It's also bad for the father. The supervisor can record anything he wants. Whatever he writes down, the court will take as fact. Supervision provides infinitely malleable material for the courts to make damaging findings. It's also very expensive. I have to do visits in Los Angeles County, California. The flights and supervision run to over $2,000 per visit. No parent should do supervised visitation. It's bad for the children, bad for the father, and allows courts invent false findings to further endanger the father. Okay, then he talks a little bit about this. Okay, so let's talk about a few things here. I mean, one is he's got supervised visits. We'll walk through that. He says even doing them is a bad thing. Okay, it enforces in a child's mind that the father is dangerous. Perhaps the supervisor can record anything. Okay, we'll talk about that. It's also expensive. This is where I wanted to start though. I will do visits in Los Angeles County. The flights and supervision run to over $2,000 per visit, which makes it sound like the supervisions are expensive. They're not. And I checked in Los Angeles County. I could go through the links here. $75, $100 maybe a visit, and up to how many hours, I don't know, but that's typical time. A few hours, $75, right? Maybe $100. So he's talking about the flights out there. That's really the thing. But you can schedule those flights. And I will say this, and we will break into, you're like, who's this? What's going on here? I will talk about that. We'll walk through that as well. But I also just want to say, if your child is for some reason removed and it's in a different state, why are you not in that state too? Okay. And people are like, oh, but do you have to? Look, there are things out of your control, which is not out of the kid's control. I mean, it's out of the kid's control too, which is this case got moved to California from Texas. Why is he not in California with the kids? That would be number one, right? I don't know. He's like got supervised visits. Well, then it's what it is. Okay. But I would do everything I could to be in the same area as my children. The fact that the mother moved away, she got order granting her to do so, sucks. But why are you not in the same state, county as your kids? Okay. I mean, that should be just number one. Not doing supervised visits. Supervised visits can be, it depends on the extremities of them. They can be done with family, someone who's going to be a supervisor, or they're at a facility. Okay, these facilities can, and they do oftentimes, record everything. Now, the idea is you shouldn't be talking to the kids about the case. Okay, that's just, the kids are too young for this. Even this situation, and we'll walk through this one here in a tad bit. You shouldn't be talking to them about the court case. It's just nothing to do with them. So that's really, or putting them in danger or whatever. So that's typically what you see in a supervised facility. They're recording they'll make comments about the visit, what each party was saying. And for the most part, you should just be chatting and talking to him. Now, this guy's like, I'm not going to go do it. I'm not going to do it. It's okay. So here's the problem with that though. The court will grant you additional time, once you do supervised visits. They don't want supervised visits all the time, unless you're just always considered to be a dangerous person, right? So you'll get past it. But you have to do the supervised visits. It sucks. It's not good. A lot of judges don't like to do, and we read about this in Nick's case. The judge themselves and even CPS were stating that we don't think that the facilities, supervised visits and the professionally supervised are really the way to go about it. It's not the best way for the kids, okay? Even that judge understood that. But you've got to do something. You've got to show that you actually have an interest in these kids. And I understand what this guy's problem is. We've been there. We'll talk about that. So he says it's not even a good thing. I don't agree with that. Okay. At some point, the kids, even if they think it's like dad's dangerous, well, all the kids know is that dad is making an effort to see them. Okay. And I'm not in this guy's situation. I get it. So we understand all that. Okay. So Tyler, what's this situation about? This guy, this Jeff Younger, he was, lived in Texas with his wife. He had twin boys. She wanted to trans them. Okay, one of the boys thought he was going to be a girl. So mom's all in favor of this. So she is getting orders to do so, custody orders, and she moves to California, where it's a little bit more safe for this kind of thing. Matter of fact, under the best interest of the child standard, one of those is gender affirming care. Okay, so if your kid comes out and they want to be, they have mental illness, and they want to be a girl and they're actually a boy, or they want to be a boy but they're actually a girl, and you don't go along with that, it can be seen as not being the best interest of the child, which is the standard for who gets the child, okay? So mom wanted to move to California. Now, everyone sees this court case and they lambast California. Yes, because California sucks for many things. This guy, one of the issues here is like fathers have no rights. Well, that's not true. We deal with this all the time. Fathers get a good shrift. They get a good shot here in California, okay? Actually, probably better than they do in other states. And that actually started in Texas. This case started in Texas. So let's read his appeal, because what happened in Texas was what started the whole problem, okay? And that's where his case was. He looked to move away from Texas. Now I'm gonna have to fix this thing again. The mom wanted to move away from Texas for, what I think are not necessarily great reasons. And he was, oh boy, let's hang on here. Get this down here. Okay, there we go. We're getting a little better. Oh, we go. So she wanted to move to California from Texas, and he filed an appeal. And this is the answer to this. So when we talk about all the horribleness that happens because, parties are in California, sometimes you need to understand that it has actually more to do with not just California. In this case, is also Texas, okay? Texas had some problems. And Texas, actually, I wonder what they think about it now when we walk through this order, because here we go. Okay. Sorry, I want to fix this here. Justice Blackrock, joined by Justice Young, concurring in denial of the petition for writ of mandamus. This pro se mandamus petition arises from a child custody dispute involving twin boys, one of whom has exhibited confusion about his gender. Mother, who has custody of the boys, recently moved to California after a Dallas County District Court in September 2022 authorized mother to reside with the children anywhere in the continental United States. Father, the relator in this court, is concerned the mother's move to California will bring the medical transitioning of her son. 3 months after the district court authorized the move to California, father belatedly seeks an emergency order from this court requiring their return. I concur in the court's denial of the petition because father is already in possession of a court order prohibiting mother from doing precisely what he fears she will do with his son. In October 2021, the described by its lead author as a, quote, trans refuge, unquote, bill designed in part to respond to, quote, executive and legislative action in Texas, unquote. The bill, and this is a press release by Scott Wiener, he's a horrible person in California, California State Senate, Senator Wiener's statement on bill to provide refuge for trans kids and their families, September 30, 2022. Okay. Bill, I think it was 1042. The bill certainly casts a wide net in pursuit of its objectives. The bill contains several provisions barring enforcement in California of, quote, a law of another state, unquote, or, quote, another state's law, unquote. That prohibits gender affirming, I can't keep going, quote, quote, gender affirming care. Thus, SB 107, both as advertised and as written, is California's response to other states' legislative enactments or administrative rules outline gender transition therapy, while SB 107's position on other states' laws is clear. I see no provision in the bill that would alter the enforceability in California, or a Texas court order requiring divorced parents to agree before subjecting their child to gender transitioning therapy. Okay, as what you're seeing here is the Texas court is saying, we're going to deny his request to make her stay here, or actually make the kids stay here. We're going to let her move over there, partly because this bill in California, which I don't believe had been enacted as law as at this point. It was a press release of what they were going to do, which has now been enacted as law. As stated at this time, was sure, it's a refuge for gender affirming care, but we believe that the order in place in Texas is going to supersede this. Okay, the Texas order, which blows me away that this court doesn't realize that what mom is probably going to do next is establish residency there, and then file to have this case moved to California. Right. They literally take the file out of that one jurisdiction and they move it to another. And it typically have to be adjudicated by the state where the jurisdiction where the actual case it currently is, which in this case was the one in Texas that already gave mom, she'd have to petition in that court and say, oh, the kids don't even live here anymore. We should be able to move. And dad's going to argue that it's there, but then her argument is also, yeah, but I have full custody. Why should I have to come? I've already been, matter of fact, there's been an appeals court that said I can go. Why don't we just move the whole case? Convenience, okay? Convenience. And then once they're in California, she can ask for new court orders because these are temporary orders for children. Then she could ask for new. So none of this makes sense from the Texas point of view. And Texas has a lot of the problems in this case, okay? You allowed it to come to California. Mom obviously was doing this to come to California to trans these kids, or at least one of them. And she was successful. And now, as we read the tweet from the guy, it is, mom has been, and what I've been able to see, mom has been able to now medically castrate the kids, or one of the boys. Father reads SB 107's prohibitions on the enforcement of another state's, quote, law against gender transition therapy as a prohibition on enforcement in California of court orders limiting access to such therapy. It is not a court order allocating the parental rights of divorced parents based on case-specific judicial findings about the best interest of their children is in no way a law of another state. And in very unlikely event, California's courts interpret their statute in such an odd way, they would run course headlong into the full faith and credit clause of the U.S. Constitution, Article 4, Section 1. Well, they didn't. So maybe Dad hasn't fully gone through all the legal provisions he needs to here. The bill's authors were likely aware of the prevailing intervention of the full faith and credit clause, which states, have some leeway to deny enforcement of other states' laws, have some leeway, okay, on policy grounds, but little or no leeway to deny enforcement of other states' court judgments. Granted, I get it. The problem is when you transfer the case, now you are not dealing with because once again, she moves to California. The court order in effect is the Texas court order. It doesn't matter where she's at. That is the state's, the court order that determines the custody, whatnot. However, once she transfers jurisdictions to California and then requests to modify the court orders, which she's done, I believe. Now you're not dealing with full faith and credit anymore. You're looking at a new order, replacing the old order that was enforced in Texas, which now doesn't have jurisdiction anymore because they've relinquished jurisdiction to a different state court, okay? And with that, somehow this appeals court didn't recognize this. So this is on them. Okay, it's on Texas. If you want to blame anybody, you blame Texas. The Supreme Court's decision supports no roving public policy exception to the full faith and credit due judgments. Once again, this is not a judgment. This was an order. I believe, I don't know all the aspects here, but I've got to believe it was just a simple custody order, and it's not, they hardly ever do permanent orders, okay? If you do a permanent order, getting over that and trying to modify custody provisions are very difficult. And they typically only do, I've only run into them a few times, at least in California. A mother was really not healthy in the head. She came for a consultation, and she had a permanent order against her, and I declined to take the case. And then she tried to harass me for quite some time, and I'm very glad I didn't take the case. There was a reason why the court ordered a permanent order against her. It doesn't happen. It's typically temporary orders. It's not necessarily a judgment. Okay, I get what the court's doing here. They're talking about judgments. That's a judgment that once the judgment is in effect, you don't have jurisdiction to be changing the orders within that judgment. Party A sues Party B over a fence in their yard. Party A wins the lawsuit. They get a judgment for X dollars. There you go, right? They take that to another, it's enforceable, right? Full faith and credit, all this stuff happens. The problem with this is not that it's a final judgment on the divorce, because the court has ongoing jurisdictions to make custody orders. So I have a problem with the way this is written. I could be misunderstanding some of this. Okay. Understanding this important distinction evident throughout the text of SB 107 and other states' law and the actions of another state courts is essential to correctly understand the very limited extent to which California could refuse recognition of Dallas County District Court's child custody determinations, even if it wanted to do so. While SB 107 treads close to territorial prohibition of the full faith and credit clause and ultimately may be found to transgress in its various ways, nowhere does the bill purport to prevent enforcement in California of out-of-state child custody orders establishing when parents may consent to gender transition therapy. To summarize, under an existing Texas court order, that mother agreed to, and that mother acknowledges is a binding on her. Mother lacks the legal right to consent to gender transition therapy for her son. This legal disability is just as real in California as it is in Texas, and mother readily acknowledges this as well. When a custody order specifies that joint parental consent is required, then a California doctor, just like a Texas doctor, must ensure that the appropriate parents have consented treatment administered to their children. Under the district courts, there we go. We're almost done here. Order, any doctor, under the district court's order, any doctor in any state giving transition therapy to father's son without father's permission would do so without the lawfully required parental consent. Nothing in SB 107 changes any of this. Father's further concern is that the California court could undermine Texas order at mother's request. He points to the following provision in California law amended by SB 107 as shown in bold. A court of the state has temporary emergency jurisdiction if the child is present in the state and the child has been abandoned or is necessarily an emergency to protect the child because of the child or a sibling or a parent of the child is subjected to or threatened with mistreatment or abuse, or because the child has been unable to obtain gender-affirming care or gender-affirming mental care as defined by section 16010.2 of the Welfare and Institutions Code. California Bill 107, modifying California Code section 3424A under the Uniform Child Custody Jurisdiction and Enforcement Act, UCCJEA, a version of which is the law of both California and Texas. California court is obligated to respect Texas court's custody orders and cannot modify the Texas court's orders unless the Texas court relinquishes jurisdiction, an action reviewable by Mandis. Family Code 150. Father is nevertheless concerned that the above quoted provision could be used to temporarily authorize gender transition therapy in direct contravention of the Texas order. Yet, to obtain such an emergency order from a California court, mother would have to take the position that an existing court order she agreed to now poses an emergency threat to her child. Mother has repeatedly asserted in court that Texas order is desirable and the child's best interest, which would make it quite difficult for mother to argue the contrary position to a California court. Evidently she did. And even if that were her intention, mother would also have to claim that the emergency is so dire that there is no time to ask the Texas court to amend its order, a highly doubtful proposition to the age of video hearings. The California court would have to consult with the Texas court. Yes, they would have to. And the California court would have to decide to take the extraordinary, unusual step of issuing an emergency order directly undermining another state's court's order, even though the state court was readily available to hear a request to modify the order. Almost done. Concern that any of this will happen will be entirely speculative in any case. In this case, given that mother has now represented to both the court and the district court that she has no intention of trying to make it happen, it is merely speculative but potentially prohibitive by principles of estoppel. The court cannot intervene based on tenuous speculation about what other courts might do in the future at the request of a party who may never ask. The only court to have acted as far as preserved father's right to withhold consent to gender transition therapy for his son. That right is enforceable in California. Whether mother lacks the legal authority to consent to such therapy for the child, both before and after SB 107, if the district court modifies the October 2021 order regarding medical care or attempts to acquiesce in a California court's desire to do so, father could seek immediate appellate relief. That case might raise important questions about whether medically or surgically transitioning a child against the wishes of a fit parent can be in the best interest of the child. That this is not the case. I respectfully concur in the denial of the petitioner writ mandamus. There you go. So, look, without knowing every detail on this, and I'm going to take a look here because I did have a few other links, and then we'll see if you guys are even still involved in this. I believe the case was then transferred to California. Okay, so that is my understanding, which kind of belies everything that the judge was saying there. Okay, let's go here because maybe this will give us a California judge is taking an extraordinary step of hiding the entire case from the public. Okay, well that happens. They say hide the case. They sealed it. That happens quite often. So this guy is talking about a little bit of a problem here, which is stating things that are quite often just happen, which is you have a child custody case. If it's very salacious or there's issues that they will kick everyone out of the courtroom. They will seal, almost all the cases are sealed over juvenile in California. I mean, you can't just go in there. You could get, records, divorce records, but the stuff with juveniles, no, not a chance. Not unless you're their attorney. So it just doesn't really happen. She wants to castrate the son. Let's see if there's anything here about, so this case is now in California. That's what Drew White attended, the father set, and then he ran for office. He didn't win. Okay, Younger appealed. The court rejected Younger's case after they told the court she did not intend to subject the son to treatments. However, in February, she filed a motion aiming to dissolve the protective order, preventing her from subjecting James to gender-affirming care. George Gila's motion cites the opinions of... So to do this, it doesn't sound like she did it as a bottom surgery, removal of his penis. This is just horrible. In April, Younger filed a conflicting... according to court documents obtained, filed a motion on May 30 to deem the case confidential. Okay, that's just confidential shit. But it looks like to me, they're missing over here, which is, it looks like to me, I would presume the only way to get around this is she filed to have the case transferred, and Texas had to give up its jurisdiction, and likely they did because they're now doing everything there. Otherwise, he would be in California or in Texas, barking about this whole thing. Okay, so let's go through here because there's a lot of questions, a lot of comments here, and let's see if we. I know Jeff personally. Okay. Do not enter the family law system is good life advice. Okay, that's a great question. That's one I wanted to come back to, Michael Boyle. But how do you avoid that? I tell people, I'm like, look, I'm for the most part an anarchist who don't believe in the state and all, but This is the reality of the situation, okay? You can't avoid it. So how do you not enter this? Okay, if one party wants to enter it, you can't pull the Darrell Brooks sovereign citizen routine, okay? It's just not gonna work. The courts are going to make orders against you whether you like it or not. So I understand, don't enter the family law system, perfectly fine. But if your spouse, ex-spouse, baby mama, never promised crazy a baby, hitting a bad, stupid person, hitting them up, one night stand, making a baby with them, those are all things, those are the ways you have to avoid it, okay? Those are the only ways you can, because that other person, unless you I guess, rob them of their life, because if that person files a petition and they enter the system, you are in the system, okay? And you've got to do something about it. So I don't know how you avoid that up. This is so infuriating. Yes, it is. Unfortunately, Jeff violated the family court orders in Texas and gave mother the ammo to leave them to California. It's very unfortunate. Okay, Dr. Madness, I appreciate you saying this because that is a question I had. And you're right, I had read some stuff previously about that, which is, it looks like to me that he violated it. She ended up getting custody, and I get a sense from reading his stuff where he's just so definitive on everything. Not going to take visits. Dude, sometimes you gotta bury it, right? You gotta do what you gotta do to get the kids and to do what this is the stuff we preach all the time. Sometimes it's just like, sometimes they will order classes, or, I had a client once, they ordered anger management classes to the father. And they really didn't, they said, hey, take these classes. We'll come back in 6 months, and then, you're going to have, matter of fact, your custody wasn't even really detrimentally, deterred from this. And he is like, no, I don't have, and he was so mad. He was so mad. And I'm like, man, these classes could help you. And by the way, so sometimes it's just like, look, you just got to do it. Okay, you're going to stand on principle at this point. This is not the time to necessarily be doing that. So could be a Dr. Madness that you are right. Yeah, it sucks, but should still do the visits. I agree, because at some point those kids, let me see if I can fix this, the ones showing the chat. You're right, because at some point those kids don't care. They don't care whatever's going on. They just want to see dad. And when they want to see dad, it's because they miss him, right? So why am I not seeing this? The full chat? No. Cam Solo. I think this is the one we got. All right, let me see if I can fix this here for us all, so we're able to view these things a little bit better. Okay. It's still not working. Why did she leave Texas and go to California? Okay. I'm sorry, I'm behind it here a little bit. I believe she did that because she wanted to actually do what she did, which was, it's a safe haven there. He was not wrong in his appeal, and there's a reason why. The guy is completely right about everything he said. Your excuses are garbage. How about you find the article saying Barnes never represented a Covington kid? Right now, you look like a liar. Oh. This is awesome. Okay, so let's go back here. Robert Barnes sue for misrepresenting Nick Sandman. Robert Barnes, Covington kids attorney, a new defamation suit. Robert Barnes, I represent the Covington kids. I represent and retain the. Okay. Let's see if we can find this. Dude, you're completely wrong. Secret stuff. I've posted this article multiple times. I look like a liar. Okay, let's see if this is the one. I mean, this is annoying. Unlike Sandman's, let's see. No, that's not it. Is this Robert Barnes actually commenting on here? Okay. Let's see if we have. now you're gonna kill me here. Okay, let's see if this is it here. Okay, I'm just not finding it. I will find it. It's better than Where's Dad? Okay. Let's see. Happy Friday, Tyler. You can't do anything with a slippery slope. Okay, let's see if we get. When custody cases get transferred to a different state, could old state block the new state from transferring? So here's how it works. And as we read in the appeal, to transfer, you simply go to the jurisdiction where it's at and you file the motion there. Okay, you file the request to transfer to a new county or new jurisdiction, new venue, basically what it is, change of venue. And so Texas has the holding. Now, if neither part, here's what could have happened was the county that it was filed in, the original venue, if neither party lives there anymore, okay, let's say it's, whatever county it is in Dallas, okay, and then he moves out of that county, but the case is still there, but he's still in Texas. Then mom moves out of California. Now that county doesn't hold they don't have any parties even residing in that county. They are going to look at that, even if it's going to California, it's not much different. Like neither party lives here. So then they're going to look at who has the kids. And at that point, it's likely going to, be transferred. Robert Barnes, not Sandman attorney. I mean, I've posted this up so many times. You could Google it yourself too. Let's see if I can find it. I mean, now it's going to just bother me. And I'm going to sit here and be a wanker until I find it. Now the question is, I do have it on in one of my old cases or files. I'm sorry, YouTube videos here, but I just am not finding it. It's very frustrating. Robert Barnes is a half out event. Altercations, upcoming, no, that's not it. The Robert Barnes is not Nick. Let's go, Nick Sandman attorney. Let's see if I find anything here. Oh, look at me. I may have found it, but it's behind a paywall. Okay, well, let's bring this up because this is actually what it is. I'm sorry, it's behind this paywall here, but it's Covington Catholic students, Nick Sandman's lawyers go after rival attorney. Attorney best known for repping InfoWars, got on the bad side of the legal team for the high-profile student in the controversy. This is the case here. This is the one, and I'm not gonna should I do a monthly trial? I don't know. I don't want to do that. But basically, this is the one. This article right here talks about it, and they went after him. They threatened to sue Robert Barnes. So, you can go fuck yourself. Looking forward to watching this from the beginning. Just got it. Okay. Yeah. Read this right. The way I understand is the problem here is that Texas courts approved the move. I believe you're right, Jordan. Taking family law doesn't UCCJA mean that to modify the agreement, the mother would need to file in Texas to modify home court rule? Maybe I misheard the professor. Thank you, Tyler. By the way, this is the way I've worked with jurisdictions in and out of California and between counties in California is exactly what I just described here, which is that home court has the jurisdiction and you have that order. I've had clients come from other states. We can register that order here in California, or you take this order here from California to a different state and you register it there, whether it is support order, custody order, doesn't matter. And then they can't do anything other than unless it's an emergency. And I've had those kind of things as well. And that's on a very narrow basis. And then they send you back home to your jurisdiction to do it. But when you transfer that case, when it now leaves the jurisdiction, and this is the problem with the appeal, which it talks about final judgments, but we don't deal with those necessarily because the court has ongoing jurisdiction to make orders for child custody. So you make an order now, and then 6 months later you make a different order that overrides it, and then it changes. So when you transfer the jurisdiction, now a new court California has jurisdiction to make changes. So if mom has 2 boys but wants a boy to be a girl, she just gets one. Trans, yeah. What is the big deal with a key bump doing a okay. Maybe wrong section of my notes. Uniform Child Custody Jurisdiction Act. We covered 3 interstate acts and all buried in my brain. Oh, look, the UCCJEA is just a simple mechanism so it's harder to rob your kids, right? And he's claimed that mom stole the kid. Now, she went to a different state. He filed motions. Everybody said, you can go. So that's not it. What it is, it's a uniform. All states deal with this, and if you have a conflicting jurisdictions, maybe someone goes to a different state, maybe she goes to California, tries to, they then have the UCCJEA filings, and you're in the system. They can call the home court and have a discussion with the judge. And it's basically makes it, you have to list last 5 years locations on the form, and it makes it so it's difficult, or you can find the people if you need to. Okay, that's really what that is. Would it be moral for him to commit murder of his ex-wife to prevent the surgery? Only if he's Jewish. I'm sorry, Zionist. I think we talked about that before. What's the Jew? That's what the Jew wants. Oh yeah, okay. I think you just answered that for me. Thank you. Darwin would approve. Okay, let's go here. Pseudo snark. The way I understand the uniform UCCJEA rule makes it fair to get modification because you need to go to the opposing party to modify. Who would simp for Barnes? Well, we just had a guy doing that. Check for the archive website. You guys find that. And Barnes was kicked out of the Rittenhouse. Yeah, and he was also kicked out of the Rittenhouse case. I don't really know what the. I mean, you can like whomever you like, people. Pseudo narc. That was $15. So I'm sorry, you gave me $15 for that. I appreciate it. I hope you guys are learning a little bit tonight. And yeah, look, I mean, I'm only bad-mouthing Robert Barnes because he deserves it, right, people? Not for any other reasons. I mean, let's be honest here. Let me see if there's anything else. So look, I don't, the trans law, and Mr. Younger was completely right in his concern that the wife was taking the kids from Texas to California, and that she was doing this because it's a safe haven. Now, I don't know what he did. Maybe not going and having the visits was a problem. I think it even had mentioned he wasn't doing that in Texas, so he's refused to do that for quite some time. I mean, look, I don't know what I would do if my wife was demolishing one of my kids like that. That would just be heartbreaking, okay? I would probably do everything, and this is probably what happened. He gives inferences to it there, which is he goes to supervised visits, if he was, and you're talking to the kids, hey, you want to play catch? And then they're going back, and then the courts, all these liberal courts don't like it. But remember, this started in Texas. Mother was granted the opportunities to do this in Texas. Mother was granted this transfer in Texas. So, cry all you want about the crap here in California, which I totally understand. Once again, don't marry crazy. And part of that has to do with marrying someone that is, the Bible calls it equally yoked. If you're racist, that means you should all be the same color. But what that really means is, together in religion, the same idea there. And I think that has a lot to do. My wife and I, we are on the same path, politically, philosophically, comedically, religiously, everything. We are locked in, right? And it makes a big difference because I'm not questioning whether my wife is, walking on eggshells about comments, this and that. My ex-wife used to say, not everything's about sex. And I'm like, it totally is. It's a joke. I mean, I joke about that all the time. And I was talking to my law partner today. I'm like, look, when we go to, say, wife and I, we've done this before. It was a Christmas party. We go there and they're playing stupid games, and I hated it. I hate these kind of things. But the games, I said to my wife, I go, look, every clue, I'm gonna think dirty. First thought in your mind when I'm giving Pictionary or whatever it is, it's sexual in nature. That's how we're going to start, from that level, and then we go on. And we killed it because we were all thinking in the same thing. So there you go. Okay, so last thing I'm going to look at here, I thought this was kind of fascinating as well. Steins, this is the Kentucky sheriff who was accused of fatally shooting the judge in his chamber. Oh, sorry, Blaze. Which I can't wait for this case to go on so we could possibly find things out. If you don't know, You look over here. First of all, I don't know what this quilt is doing, but this quilt's up in his office. The judge is smoking a cig, has 2 cups of coffee. He's got his robe on. His desk is a mess. The sheriff is here holding a handgun. Good trigger control, 2 hands on the gun. And he puts a bunch of slugs into the judge. Okay. And then afterwards made some comment. They're trying to kidnap my wife and my daughter. His daughter was underage. The daughter's phone number was in the judge's phone, which the sheriff looked at and called. So I am curious to find out, but I mean, the grand jury indicted him for murder. So we know that. Basically, that's what it is. Mickey Steins, then Sheriff of Lecter County, and Judge Kevin Mullins had argued just before the September 19 shooting, the Lexington Herald reported. Steins turned himself in after the shooting and was charged with first-degree murder, the New York Times reported, citing police, and retired as sheriff less than 2 weeks after the shooting. Steins, who was accused of shooting Mullins 8 times, pleaded not guilty to the murder charge. It cracks me up. This person up here that came to argue that Barnes did represent the Covington kids. Oh yeah, Barnes, sue me, because that's literally what Nick Sandman threatened to do, was to sue you and to tell you to stop being acting like his attorney. So Barnes would sue me. Did you come into this chat here because you saw the thumbnail, this thumbnail up here, and you got sucked in thinking Barnes was actually right, and you're like, sweet, I get to go. I'm a Barnes fan. I'm gonna go see where he's wrong, constantly wrong. And if you're following him and you think that it's because he's a Republican, that's where you want to go, you are being misled. Okay, you are vastly being misled by this joker. The two, him and Viva Frei, they cop for whatever. Barnes blocked me a long time ago because he was being completely ridiculous as a Zionist zealot here, and he couldn't handle any kind of pushback, and he was taking on Scott Horton. And Scott Horton's going to be on our outro, so just wait for that one. But that's fine. The shooting particularly curious since Steins and Mullins reportedly had been decades-long friends. What's more, the pair went to lunch that day. Everything seemed fine between them. There was no clue that anything was wrong at all. Employees said, you wouldn't have guessed there was the slightest problem. Okay, and then he came back and shot him. So he's been indicted, and I can't wait for that case to go to trial. And hopefully they will get some kind of. I want the guy to testify. That might be his best bet, because it's obvious he put the gun. I mean, it was brutal to watch. It was like Nick Freitas opening the door and macing the lady. It was obvious what's going on. This guy just shoots. The judge is hiding under the desk, still live, and he's the officer, the what's his name, the sheriff, is then reaching down. He's shooting. He's going over here. He's shooting, and he took a lot of strains, a lot of efforts to make sure he put that guy down. I think that's where we're going to end. So here's the thing. Never promise crazy a baby. Make sure you hook up with the right person. Find yourself equally yoked. That's the right thing. Don't hire Barnes as your attorney. So I will post this. For those of you curious, I will post the link to, I'll find the better, what do you call it? Link to the article about Sandman and his attorneys telling Barnes to fuck off or they're going to sue him. I'll post that in the links. By the way, you can find this show. We tweet, we go out on Twitter, we go out on YouTube, we go out on Rumble, LPR on Rumble. You'll find us there. All podcast catchers. I mean, look, if you go on the go, check this show out. I mean, there's a little dead air tonight. There's some problems at the start, but this is what we have for the most part. Friday nights, 5:15. We do check. Obviously, when you click the button and you hit the bell to notify you, if you do the Rumble one, that one is the best for giving you notifications. It at least does a pop-up on my phone, which is a bit annoying, but it'll tell you when I'm going live. So typically 5:15, 8:15 on Friday nights, but we do some during the week. This next week, we got Thanksgiving coming, but I don't have any court. So I will likely do maybe a follow-up. Maybe we'll talk about Rittenhouse and how bad that guy is. So let's see. Johnny Somali making privacy claims against YouTubers, legal mindset. What's funny is that somehow it's not after the Rittenhouse comment. I don't have any more popping up here. So let's go to here. Check the archives website. Kick that over. Okay. What does a Jewish person say to a trans woman? Clipped a little deep, didn't they? get married, just never had child abuse. Pseudo Snark says, you know what? Let's try this one. Oh, no, it's not going to do it. I'll show you this here. So if you see here, see the last one I had was the Barnes. So for some reason it's not coming into my chat here. That's fine. I agree if both parties are the same state, but when parents start in state A, divorce, mom leaves, dad stays. I think they should need to go to Texas. I think it's IC 312133. I'm not sure exactly what you're saying, but I'm just telling you that you do go to Texas. You go to the home state to petition to go to the next state, okay? You definitely explain, that's all theoretical to me. You should have gone with Shaggy defense. Okay, Popcorn. No Barnes fans here. Okay, I don't understand why Viva Fry just does monkey shines. He knows better. I guess he really needs an American sidekick. He's just sad. What's funny is that he was on the Duran a year ago with Scott Horton book in his background. Dolly Smalley making privacy claims against YouTubers' legal mindset. Oh, that's interesting. Yeah, so let's talk about the bar, and then we'll leave here. Which is Scott Horton went on Viva Fry, and it did not. It was It was not acrimonious. It was contentious. Right after September 7, it was interesting. Now, Viva Fry is not good at arguing, so you know that's point one, or debating. So it was just a bloodshed. And then Robert Barnes is just doing declarative statements about how ridiculous Scott Horton is on Twitter. And that, to me, that was and that was actually my comment. I'm like, interesting. For such a smart person, you can't argue with him. You just have to make declarative statements. Then, you know, he blocked, which is Horton dog walked Viva. Yeah. And then, Dave Smith came on as well. So anyway, people, I think we're going to be done with that. I really appreciate everybody coming in tonight. Sorry about the technical difficulties on the front end. I think we got them cured up there. I was a little hyped up. I've got to make some personal changes. You guys, you're going to talk about some personal stuff, and then we're going to leave for the night. Maybe I need to have the all right, some slow music. I need to go to the gym. I need to get on my bike. I need to exercise. My wife is killing it. I've killed it all my life. Had one stretch in there where I wasn't. I broke my neck and my back a few years ago, and that's not the excuse. That's just the start of what happened, right? It like got me off track. Got back to the bike, get back to the gym, and then I had another back problem kind of related to the neck and back breaking thing. And there's nothing prohibiting me from going. I'm busy. I love doing this show. I'm working a lot. Life is good, but my health needs some help. So I sounds like you need a massage. I do. I'm gonna go talk to my wife. Maybe she'll grant me one of those right now. Okay, people, we're out. Once again, like, subscribe. Don't forget, watch out for Barnes. There's gonna be some exciting things coming up. What we're gonna do on the outro, it's Scott Horton on Piers Morgan. He said some things. I would just say I would not do this. This is not my favorite way of arguing, but it was therapeutic and it was kind of nice. Okay, see you next week, guys. Whoa. Okay, let me try this one more time. Let me see if I could do outro.
Well, according to this guy, democratic revolutions are never possible. We had one in this country in 1776.
What are you talking about? I didn't say that. Why don't you argue with something I said, you dumb bastard?
The idea that the guys that use...
Things are going to start happening to me now.
I think Tyler is amazing.
And I'm a fan of this show. I've watched several episodes.
Thank you, Tyler. Thank you, Tyler. You stink, Tyler.
Never promise crazy a baby.
Oh, I like that. That's a cool idea.
Are either of you homosexuals?
I go both ways. What do you think?
You mean like flaming, or?
No, we're not homosexual, but we are willing to learn.
But I do wonder, for others, in other cases, whether libertarianism today is just an excuse for many on the right to act selfishly.
Look at me. And then some fat asses in Washington started having opinions. The Olympic Committee started having opinions. You bitch, I know you. You started writing your opinions.
And it just makes me wonder, you're dead, bitch. You know, why are you doing this to this poor guy?
I don't care. I'm a libertarian. What I'm getting is...
Did you vote for Judge Jorgensen or Trump?
Who?
Joe Jorgensen.
That was the perfect answer. Thank you. That